We are here today. Now we are here today, now that the recording has started, to do a Best of the Legal Hotline topic for you today. You may have seen a few things over the past few months regarding this NAR settlement. The attorneys here on the hotline were very keen to make sure we did a presentation that did not talk about the settlement. We were going to fail at that because we are going to talk about that among a bunch of other topics here today. But as we go through here, I think we're going to at least be able to mix up at least some settlement related things with a lot of other things that you're going to find very helpful as we move forward here into the fall. So we're going to start off as we usually do with some introductions, just so you know who you're talking with here. I'm Hank Lerner. I'm PAR's Chief Legal Officer. Casey Klauser, Paige Perucci, Desiree Brocker are the other three attorneys here in the department. They will all also be on. We're all going to have our own topics as we go through here to discuss this, and all four of us are the voices that you will hear on the PAR legal hotline. So if you should ever get anybody who calls you and says, "Hi, I'm calling from the hotline," it's going to be one of the four of us returning your call so that we can give you an answer to your question. The topic for today is the more things change, the more they stay the same. What we are finding in terms of an overall trend on the hotline these days is that there are folks who are, in some cases, sort of dropping some of the basic stuff that they know about real estate because they're getting a little bit confused or tied up in some of the settlement issues that are going on. But also, we found that the agent population, which, as you know, has a lot of turnover every 2, 3, 5 years, has turned over a lot in this weird market that we've been in recently. So we've got a lot of folks in the market right now in real estate who are maybe seeing things for the first time that they haven't seen before. So it's new to them, even though it's not new maybe to other people in the office or to us on the hotline. So we want to kind of get back into covering some of those things just to make sure everybody has a little bit of a baseline of understanding of what's going on. So what are we going to talk about in these topics here today? We're going to start off with a discussion about some agency-related things. We're going to talk about seller concessions. So you can see we're going to start off with a couple of specifically settlement-related items. We're going to talk about the timing of the cooperating broker compensation form, moving into inspection contingencies, the mortgage contingency, because again, there's a lot of people these days who maybe have been waiving inspections since they've ever gotten into the business, or they haven't had a lot of experience negotiating under the mortgage contingency. We're going to talk a little bit about loan to value versus the appraisal contingency addendum, because there seems to be some ongoing discussion and confusion about that. And then at the end, there's going to be a bonus round with some additional hints and tips that will be helpful for you if you're going to be contacting the hotline. So let's just jump right in at the beginning here with a discussion about agency. So the first thing we're going to talk about here is just to remind everybody on the call that under the rules of agency, under the law of Pennsylvania, all of the contracts, buyer agency, seller agency contracts that you sign are contracts that belong to the broker. The broker and the party have a contract. It is not the agent and the party who have a contract. Why are we reminding you about this? Well, because of some of the calls that we've been getting where people seem to be a little bit confused as to who can do what in that agency relationship. For example, people, especially now in the current environment, are calling in to discuss different fee structures that they might want to charge, whether to sellers or to buyers, and they want to know, can I do this? So we can address a little bit of the questions about legality or whether it might possibly violate terms of the settlement. But at the end of the day, the contract is between the broker and the client, not the agent and the client. So the question about what fee can you charge, assuming that it's legal and ethical to do something, actually comes back to you need to talk to your broker about whether there's a brokerage policy on fees. That's not something PAR can answer for you. Lots of people are calling in to say, well, should I even be offering cooperating compensation? How do I want to do that moving forward? Again, cooperating compensation is broker to broker. That's how agency works. So talk to your broker. Your broker can set policies on cooperating compensation. You would need to follow those policies if they have them. There are a lot of questions about people wondering, how can I get paid if it turns out that the other broker or the client is not going to pay me? So they've said they're not going to pay my fee, or we get to closing and something's not right. Once again, that's a brokerage question. We have a fair number of people who call in basically saying, my broker said that they won't go after the client. How do I do it? The answer is you don't. Agency says the contract is between the broker and the client. You have to talk to your broker about that sort of thing because it's really the broker's fees. In-house transactions. Now that cooperating compensation looks a little bit weirder, people are starting to think about it a little bit more. They're thinking, well, gosh, how does this work in an in-house transaction if my brokerage has both the seller and the buyer? How much money is the buyer broker entitled to? The answer, again, that's a brokerage policy. The buyer broker in an in-house transaction is by definition not a cooperating broker because they're in-house with the listing broker. So that is going to be an internal brokerage policy. Brokers, you probably need to think about updating or possibly writing a policy that says how you divvy up internal fees. And agents, you should be asking your brokers about that because that is what's going to define how you are going to get paid. The next item that we're getting a lot of questions on is designated agency. So the definition that you see on the screen right here comes right out of the statute. I believe that we have a link to RELRA that we're going to be able to post in here. So just look in the definition section or type in designated agency or designated agent to get this definition. Designated agency is when one or more licensees designated by the employing broker with the consent of the principal, that's the client, to act exclusively as the agent or agents for the principal to the exclusion of all other licensees within the broker's employ. It's a lot of words, so let's break that down a little bit. One or more licensees designated by the employing broker. So first of all, the broker needs to have a policy on designated agency. Do you practice designated agency or do you not? Because the broker has to do the designation. It can be one or more licensees. We'll talk about that in a minute. Oftentimes, there's a policy that says the person who signs the contract as the agent on behalf of the brokerage will be the person who is designated, but it doesn't have to be just that person. In fact, sometimes it isn't even that person, depending on your processes and how that works. But it is designated according to a brokerage policy. And these designated agents act exclusively as the agent or agents for the principal to the exclusion of all other licensees. So what does that mean? If you do not practice designated agency, when somebody signs a listing contract, technically all of the agents in that brokerage now represent that seller. If you sign a listing contract where the person who signs it becomes the designated agent, only that individual agent represents the seller. Nobody else in the brokerage represents the seller. Nobody else in the brokerage should be hearing confidential information about that seller or performing real estate activity that benefits that seller. You're going to want to remember that here in the next couple of slides. So are you a designated agent in your transaction? We're kind of a broken record here. I don't know the answer to that question. Only your broker can answer that question for you because it will depend on brokerage policy. Now, a couple of questions I can almost answer. What about teams? How does designated agency work within teams? Well, the question you have to ask yourself if you work with a team is who on the team is acting exclusively as the agent or agents for the principal to the exclusion of all other licensees. So if you have a team of 10, 5 of whom work with sellers and 5 of whom work with buyers, and any of the 5 who work with sellers could work with this particular seller, then the answer probably is that the team needs to talk to the broker, and somehow all of the 5 agents who might work with that seller should be designated to be designated seller agents because they are the ones that would be doing licensed real estate activity on behalf of this client. They are the ones who would be seeing the confidential information. If the team is set up that only the person who brings it in is working on their behalf, then maybe that's the only person who has to be designated. If you have it set up that team leaders are able to see all of the files and participate in transactions, whether they're the lead on a particular transaction or not, then maybe it's the listing agent who signed it and the team lead who have to be listed. That is not, again, a PAR policy. That comes down to a brokerage policy, but the question is a practical one. Who is going to be acting on behalf of the client and make sure that that person is designated? Similar question that we're getting a ton these days is what about showing agents or what I'm just calling sitting agents, which is probably not a term of art, but we're going to go with it. So I'm a buyer agent. I'm really busy. I've got a client who needs to do a showing, so I ask somebody else in my brokerage to show the property for them. Or I've got 3 clients who want to have open houses on the same weekend. I can't be in 3 places at once, so I ask 2 other agents to sit at those open houses for me. Ask the same question. Who is acting exclusively as the agent or agents for the principal to the exclusion of all other licensees. So if a buyer is going to be going out with a different agent in the brokerage, and that different agent in the brokerage is going to know information about them and perform license activity on their behalf, perhaps the broker should be thinking about having a policy that says, well, in that case, we're going to designate the person who's going to be that showing agent or the person sitting at the open house to act on behalf of that client, at least for the term of that particular activity. You can use our change to listing contract, change to buyer agency contract, which already has and has had for 25 years, language that lets you add and remove designated agents. So you can use that form to add and remove designated agents as you will. But again, practical question, if you are working for the client, then you probably need to be designated in their behalf. A couple other questions that we're getting that are settlement related, and we're going to close with this one. An agency does a showing agent. Somebody who is showing a house to a buyer on behalf of their buyer agent. Does a showing agent who is working with a buyer need a second written buyer agreement with the buyer? And if so, does that create a second fee obligation? We're getting this question a fair amount as it relates to the settlement. So I am the person who is working with the buyer. I ask Desiree if she would show the property. Does Desiree need a second buyer agency contract? And how do we make sure that the client isn't accidentally entitled or isn't obligated to pay two fees? This ties together everything we just talked about. The contract belongs to the broker, not the agent. So if I am the person who signs the contract with the client, I turn the client over to Desiree for an afternoon to do a showing. She still works for the same brokerage. If she still works for the same brokerage, we don't need another contract because she is still going to be covered under the same contract that I'm covered under, which is a brokerage contract. But we need to ask the question, is Desiree designated for that client? So do we practice designated agency as a brokerage? If we don't, if there's no designated agency, I can let anybody else in my office show that property without signing anything or being added to anything. If we do have designated agency, I may want to go ahead and have Desiree then added as a designated agent, at least for the term of that showing, to make sure that if there's any discussion, any confidential information, she is covered and the brokerage is covered. So that's a long review of agency there. This is probably going to be one of the longer topics you get today, so I'm sorry that I foisted myself on you for that amount of extra time. We will now turn over to the next topic, which looks like it is discussing seller concessions.
Yes, only one more topic of settlement fun. So today we'll be talking a little bit about cooperating compensation versus seller concessions. We have had an uptick of questions regarding seller concessions and just some confusion around the differences. And this is one thing that we actually didn't realize we are going to have an issue with when we started making the changes based on the settlement. And just realistically, because we're in the office drafting the forms, we didn't realize that at settlement, currently or previously, the settlement company kind of collected all the funds and then divvied it out all from one fund. So it didn't necessarily matter to the listing broker or to the buyer broker where the money was coming from. So it wasn't necessarily a path that people were aware of or that they were aware that they were following every single time. And that has kind of been the crux of what the confusion has been, I think, really just kind of how that money is flowing and not realizing how it worked before. So cooperating compensation is from listing broker to buyer broker. So historically, what people have been used to. And seller concessions are from seller to buyer broker on behalf of buyer. While it may not feel like a big deal because you're still getting paid, you're still getting money from that general fund at settlement, it does make a difference to timing and to what they actually are and how they're phrased. So cooperating compensation is that set amount in paragraph 6 of the listing contract. It's from listing broker to buyer broker out of their fee. Seller concessions are from seller to buyer broker on buyer's behalf. It is paragraph 7 of the listing contract. So I'll have that listing contract up in a minute to kind of point out those differences again as a reminder. The cooperating compensation goes on the CBC or some similar form. So that's the Cooperating Broker Compensation Agreement, and we'll talk about timing on that in just a few minutes. And seller concessions goes on that paragraph 3 of the agreement of sale. So we have very specific places for those, and we also have very specific reasons as to why. So cooperating compensation needs to be negotiated prior to the offer. Seller concessions are negotiated in the offer. That's why they go in paragraph 3A of the agreement of sale. And there are reasons for that. We'll go into that timing again in just a minute. So when looking at the actual form, just to make it visual for you, when looking at the listing contract, you can see that the cooperating compensation is in paragraph 6 and it's a set number. So that's because this is authorizing the listing agent to a specific percentage, and that is a set amount. And so that is so that agent can cooperate with buyer agent before an offer is made. It enables the cooperating broker compensation agreement to be executed prior to the offer being made. Paragraph 7 is seller concessions, and it is an up to amount and also states that it's fully negotiable in the agreement of sale. And that's because the seller concessions can be negotiated at the time of the offer. Understanding these differences is huge to timing and negotiating. Hank actually drafted an article specifically about asking the right questions to make sure you're getting the right answers having these conversations about cooperating compensation versus seller concession. So let's talk about the timing of the cooperating broker compensation agreement versus the agreement of sale. So, in terms of the cooperating broker compensation, let's look at the basics, the who, the when, the why. So, who can initiate? So, historically, buyer's agents were sending the cooperating broker compensation agreement to listing agents if they didn't like the amount that was in the MLS. So, historically, it's been initiated by the buyer's agents. However, that's not required. That's not necessary. The CBC can be initiated by either party when you're looking at a cooperating transaction. It's not for in-house deals, but it is for cooperating compensation, and it can be initiated by either side. So especially right now, listing agents are trying to get more creative about how to get that number out if they are doing cooperating compensation. So they could actually initiate that cooperating broker compensation agreement rather than waiting for it to come back from the buyer. When? The timing is before an offer is made. The cooperating broker compensation agreement should be executed prior to an offer being made. The follow-up question we get to that is why? Why can it not be a part of the agreement of sale? And that obviously coincides with when, but this timing requirement is actually from the Code of Ethics. So between Standard of Practice 3-1 and specifically Standard of Practice 16-16, it creates the need for the cooperating broker compensation agreement to be completed before the agreement of sale is submitted for an offer. So agents should not be submitting the cooperating broker compensation for execution along with the offer. They need to take care of that prior to the offer being made. So when looking at, okay, we have the timing of the cooperating broker compensation under control. When do we negotiate those concessions? And when you're looking at completing paragraph 3A, that's where seller concessions go. So we actually had a hotline call, and the voicemail went something along the lines of, paragraph 3A says in addition to, but you can't possibly mean that. And after having the conversation and explaining it, that yes, this really is in addition to, they responded, oh, so in addition to really means in addition to. It's in addition to whatever agreement you've already signed regarding cooperating compensation. So something like the cooperating broker compensation agreement or some other similar form. So whatever you put in paragraph 3A is in addition to. So if you have already completed the cooperating broker compensation agreement, and that fully satisfies the amount that the buyer agent is looking for in their buyer agency contract, then there's no need to put a number in paragraph 3A. You should not be using it as a double to make sure, oh, I just want to double check that they're aware of that. No, they're two separate things that work in conjunction with one another. Now, if you have a cooperating broker compensation agreement that maybe isn't everything that the buyer agent is requesting under the buyer agency contract, then they could try and put that additional amount in seller concessions. So they're trying to collect it as a total between the two. So maybe you have $5,000 in the cooperating broker compensation, but your buyer agency allows you to get $7,000. So you put that $2,000 in the 3A for the seller concessions. So that is something that you want to put in addition to. So you might have some combination of the two, or maybe you're only doing seller concessions, so you don't even have a cooperating broker compensation agreement, but you should never be copying the amount from the CBC to the seller concessions as a double check. It should be very intentional that they work together.
Yeah, and I just want to throw in a couple of items here. I believe Kevin is going to drop in um, a link to our resource page for the settlement, because we do have links there to all of our updated forms and all of our guidelines that actually discuss specifically these items in much more detail. So please make sure that you take a look at those. The explanation that Casey gave is a great short explanation, but you're going to want the longer one if you're doing any training internally in your offices. All right, with that, we are going to move off of the settlement related topics. Yay, everybody all at once. And we're going to move on to a good old fashioned discussion about the inspection contingency.
Yeah, so let's transition to what we all know and love, which is inspections and the inspection contingency. So we have seen an influx of inspection contingency calls lately on the hotline. We are seeing more buyers electing the inspection contingency again, and thought it might be a good idea to refresh everyone on the inspection contingency timeframe, including the negotiation period for repairs and the possibility of buyer's termination. So in paragraph 13A, the period of days is either filled in with a period of time the parties choose, or 10 days as the default selection. During this period of time, the buyer has to conduct any elected inspections and decide whether and how to proceed with the purchase of the property based on the results from the inspection reports. So those two vital steps for the buyer are due on the last day of the contingency period, along with a copy of the reports. As you know, the buyer has three options: accept the property, terminate the contract, or send a written corrective proposal to initiate negotiations. So let's say the buyer sends their response early and they choose to send a written corrective proposal. The parties have a 10-day contingency period in the contract, and buyer sends their response and reports on day 6 to the seller. The seller is not obligated to respond to the buyer until the day after the inspection contingency period ends. The buyer submitting the corrective proposal does not accelerate the rest of the timeframes. It still stays at that 10 days, 5, 2. Unless the parties have selected other date or other times in the blanks. So let's continue with the buyer choosing to submit a written corrective proposal to the seller. By submitting this, both the buyer and the seller are locked into a negotiation period for however long the parties agreed to in the agreement of sale, 5 days being the default period. The purpose of negotiation is to come to the final mutually acceptable written agreement for either repairs to the property or credits to the buyer. And again, with the caveat that this is all acceptable to the mortgage lender. At no time during the negotiation period should the buyer make the actionable step to terminate. If negotiations are not to their liking, the buyer must wait until the negotiation period is over to terminate the agreement. See how important it is to know these timelines to make sure to protect your buyer, your client in this situation. So if there is no mutually acceptable agreement after the negotiation period ends, the buyer has to decide whether to accept the property or terminate. This period of time decided by the parties with a default of 2 days, if not specified. So some last things to note with the inspection contingency. The BRI, or Buyer's Reply to Inspections form, can be used as a written corrective proposal. If a buyer and seller come to a mutually acceptable written agreement, then the CTA, or change in terms addendum, can be used to finalize the terms agreed upon. One more thing to note, when we receive calls that the buyers elected contingencies, but, quote, for informational purposes only, we know that we probably can't give you much insight about what might happen next in that transaction. Why? The phrase for informational purposes only could mean anything and could mean very different things for both parties. Buyer's intentions for those words may be vastly different from what the seller's interpretation is, and we are not mind readers. So in that sort of situation, PAR attorneys cannot interpret language that we did not draft. So in those rare circumstances, we will recommend your client speaks with an attorney. So final thoughts, make sure you know your timeline for the inspection contingency. If the parties selected the default days in the agreement of sale, it will be 10 days for inspections, 5 days for negotiations, and 2 days for the buyer to accept or terminate. Each period of time has a specific purpose for the buyer and the seller. Beware of those days that would fall on, potentially holidays. Keeping an eye on that and making sure that you know your time frame when you're writing the offer. And remember, seller does not have the right to terminate under the inspection contingency. The concept there being that if the buyer accepts the property and moves forward, they're still in the same agreement with the seller. So just because the seller might be annoyed during the negotiation process, if buyer ultimately does decide to move forward with the contract, the seller does not have a right to terminate.
All right, and I will say that one of the more disheartening calls that we get on the hotline is when a party has the right to do something, but they jump the gun, or there's an outcome that could be possible, but it ends up that somebody's in default because the agent was not aware of the specific language, so they ended up giving away their client's position inappropriately. So hopefully this will give you a good reminder of this one. And again, check out our guidelines for the actual form if you want to get a little bit more information on how some of this works. With that, we're now going to talk about another commonly misunderstood contingency with Desiree, which is the mortgage contingency.
Yes, there seems to be a little confusion over what paragraph 8 of the standard agreement does and does not do, or what it means and does not mean. We see people quite often taking the structure of the inspection contingency that was just explained and applying it to the mortgage contingency. However, the two paragraphs are written differently, and although both are contingencies, they follow different procedures. So as Hank just mentioned, and as a reminder for you, the guidelines for preparation and use are available on the website. That is one of the benefits of your membership, and they may answer some of your questions. For now, though, we can consider this your little refresher course. So, paragraph 8 of the standard agreement of sale addresses buyer financing. It's called buyer financing because there are parts of this section that are going to apply to the transaction if buyer is getting financing, whether or not they have elected the contingency. Those certain things are found in subparagraphs A through E. You can see on the screen a short list of what those subparagraphs address. As I said, all of these things apply if the buyer decides to get a mortgage at all, not just if they elect the contingency. So if you happen to have a copy of the ASR in front of you and you're following along, subparagraph A is all of the things that the buyer and seller are agreeing to do if the buyer decides to get a mortgage. For example, if buyer waives the mortgage contingency but decides to apply for a loan anyway, then the seller is going to have to provide access to the lender and the lender's representatives. Why? Because they've already agreed to do so in paragraph A3. Also, the buyers must make a timely mortgage application, participate in that mortgage process in good faith, and lock in interest rates when they get the chance to do so. Subparagraph B is a description of what the loan-to-value ratio is, and we'll talk about that a little bit more later. Subparagraphs C, D, and E apply to VA and FHA financing. Again, these subparagraphs apply if the buyer gets a mortgage. Getting a mortgage and electing the contingency are not the same thing. So hopefully you aren't telling your sellers that since the buyer's selected waived, that there won't be a mortgage or it's a cash deal. The waiver is of the contingency, not a mortgage altogether. So let's take a closer look at the actual contingency and how it works and does not work. For starters, what the mortgage contingency does is protect the buyer's deposit if they cooperate with the mortgage process. This means that it will not be a breach of the contract if the buyer is unable to get the loan for closing. What the mortgage contingency does not do is give the buyer the right to terminate the agreement if they get a denial. And I'll repeat that because this is important. The mortgage contingency paragraph does not allow the buyer to terminate the agreement if they get a loan denial. This is spelled out in subparagraph F3, beginning on line 181. It says explicitly that termination of the agreement by the buyer due to a mortgage denial may demonstrate bad faith by the buyer, and they may end up forfeiting their deposit to the seller. The seller is the one who is given the right to terminate if the buyer gets a denial letter, or, to put it in the words of the contract, fails to deliver a copy of the documentation demonstrating the lender's outright or conditional approval of the buyer's mortgage application. If the seller terminates for this reason, and we're assuming here that the buyer did everything right in terms of cooperating with the mortgage process, then the buyer gets their deposit back. If the seller does not exercise that right to terminate, then the buyer is obligated to make a good faith effort to get the financing that they said they could. What a good faith effort is will vary based on the circumstances and the buyers. Not to mention that the seller is actually given the option to contribute financially in order to make the specified loan terms available to the buyer. As long as the buyer makes this good faith effort and has not done anything that would cause the lender to reject or refuse to approve their mortgage application, the buyer's deposit will be protected, even if they run all the way up until the settlement date and can't get the loan. That is how the contingency works. So we get asked all the time, but what if the property doesn't appraise and the LTV is exceeded? Isn't the LTV a built-in appraisal contingency? Well, the answer is no, because there's still no right for the buyer to terminate. The LTV is the loan-to-value ratio, and it is not an appraisal contingency. What the LTV is basically a cap on borrowing, and it's a way for the buyer or the lender to say that they only want to borrow against a certain percentage of the property's value. For example, if the buyer is borrowing $200,000 and they cannot borrow more than 80% of the property's value, then the property has to appraise for at least $250,000. As I just explained, the mortgage contingency does not allow the buyer to terminate the agreement of sale. So even if the property appraises low for $220,000 and the LTV is exceeded, because that would be 90% of the value, then the buyer isn't given the right to terminate. What happens instead? As I just explained, the seller has the option. And remember, when I say option, it means the choice, not that they have to do so. The seller has the option to contribute financially to make the loan terms available to the buyer. So that could look like the seller lowering the purchase price, meaning that the buyers could borrow less. It could mean that the buyer reviews the appraisal with the lender to see if anything was missed. It could mean getting a second opinion. It could mean the buyers put more money out of pocket towards the purchase and not borrow so much from the lender. All of those things can be options, but termination by the buyer is not one of them. The buyer is only given that right to terminate via option 1 of the appraisal contingency addendum, not by electing the mortgage contingency. If your buyers want the absolute right to terminate as the result of an appraisal, they must include an appraisal contingency. Hopefully, all of that helps.
Yeah, and I'll provide a perspective here. This is one of the things that I often use on the hotline in different circumstances, which is what I call the index finger rule. So everything that Desiree just said, everything that Casey just said comes down to the index finger rule, which is, can you take your index finger and trace along the words in the contract and find words that say buyer can terminate, seller can terminate, whatever it is that you want. If you can't find those words in the contract, you should assume that your client does not have the right to do the thing they want to do. Certainly you can call us for confirmation, but it's really not about what you think you've been told, what you've been trained on, what you've heard, or even what logic might seem to dictate. It's about going through the actual words of the contract and making sure that you're able to read them and fully understand them and explain them to your client. So with that, we're going to move on to our bonus round. The bonus round is what we're calling hotline limitations. Now, I'm just going to preface this by saying that it may sound like I'm starting off with a bunch of negative stuff here. This is not meant to be negative. This is meant to be hints and tricks that will help you have a better experience when you think about calling the hotline, because we want to make sure that you understand what we can and cannot do for you as a member service. Because especially if there's things that we can't help you with, it's going to be a lot faster if you know that in advance and follow that the appropriate path to get that answer, rather than taking the time to call us, waiting for a return call, only to be told that we can't help. So starting off kind of where I started off today with agency, we cannot deal with anything having to do with brokerage policies. So if you've got questions about what you should be charging, what you can be charging, you've got internal disputes. We get a fair number of people who call because they think they should have gotten paid X from a particular transaction, but the broker paid them Y. Any questions about agency policies and how they handle internally, all of those internal brokerage issues, PAR really cannot help with in any substance. We might be able to tell you where there's for example, the arbitration process might help if you really have an intractable financial dispute with your broker. Maybe there's a few resources we can give you, but we can't weigh in on those substantively. We cannot assist with the details of any MLS policies. As you might imagine, with the settlement and the recent MLS rules changes, which is what's really implementing it, we have a lot of people asking questions about, like, what can I put in the MLS? What can't I put? How do these fields get used? We perennially get questions about when I need to change a status from active to pending, under contract, things like that. How long until I have to put a listing into the MLS? How do I deal with an in-house listing? All of those questions are questions of local MLS policy. So again, even though we can give you some general answers sometimes, that will always end with, but we can't give you specific answers. You need to talk to the MLS about that question. So sometimes it's better just to start there. We cannot approve any language or interpret any language. So if you call and say, can I send you a copy of my fill in the blank so you can tell me if it's legal, if it meets the regulatory requirements for advertising, if my website is going to get dinged by the State Real Estate Commission, we can't do that. Paige mentioned the informational inspections for informational purposes only. There's lots of people who find language online, or because somebody in the office thinks it's a good idea, so it gets copied. We can't help you interpret that. We can't draft language for you on those sorts of things, because again, that's outside of the scope of what we can do. We can talk for hours about PAR's words in our contracts. We can't interpret your words that you wrote. We don't know what you're thinking. We don't know what everybody else was thinking. Another limitation, we don't give advice to clients. So if your seller or buyer or landlord or tenant wants to know what to do next, we do not give them advice. So no, you cannot conference them in with us. And if you do conference them in with us, even after we told you not to, that's not going to go well. So please don't do that. But it also holds if you are the client. So we know lots of real estate agents own property, buy, sell, lease their own property. We can give you some general information about how the landlord-tenant law is supposed to work, for example, but we can't look at your lease. We can't tell you what to do with your clients when you're renting a property because you then are the client. You are not acting as a realtor for somebody else in a transaction. And while we appreciate the the feedback and the confidence that you may have in the hotline when you call in asking for advice on how to divvy up your property in a divorce settlement, what to do with employment of people in your office, how to deal with tax laws, that is far outside of the scope of what we handle. We deal with real estate transactions, code of ethics, forms, things like that. We're not an all-purpose legal hotline for all things. We are limited to your transactional real estate business. And just so you know, all of those things we have had questions on in the past. I'm not just making that stuff up. And I will remind you then, we do ask you to call the hotline phone number. The hotline phone number is not going to be given out on this because this webinar could be available to people who are not members. That's why we do a good job of hiding the number so that we do not have non-members or random consumers calling us. But please try to call the main hotline number. If you cannot get the hotline number, please call PAR, which is 1-800-555-3390. And the PAR Solution Center will double check your membership and can give you the hotline number. But please call the hotline directly so that we can make sure we get your call as quickly as possible. You don't need to call us twice in a day. If we miss you and leave a voicemail, you don't need to call us back. We will just put you back in the queue and we will get to you when we get to you. Having extra messages just means it takes an extra couple of minutes to realize it's a duplicate. And again, while we do greatly appreciate all of the personal connections that we've built up over the years, it's actually always faster for you to contact the hotline than to contact one of us directly. Particularly ironic is a day when somebody tries to contact one of us directly, but we can't get back to you because we're working on the hotline and we're not checking our email or our voicemails and looking for those messages. So you actually end up being delayed in that response rather than getting it ahead of time. Final reminder then is please leave a message with content. I have a question about the agreement of sale. Doesn't really help us sort of beef up the answer before we get there. I have a transactional question. Again, not super helpful. We will sometimes even be able to email you or leave you a voicemail if we know the details of your question, but we really can't do that if you just say what your name is and your phone number. So please go ahead and make sure that you leave the full message. We've got a reminder at the beginning of that hotline voicemail as to what it is that we need to do. So with that, I want to thank you again for your attention here today, and we look forward to talking with you on the hotline in the future, and we'll see you for our next seminar in a few months.